All right, so let's talk about Jussie Smollett's attorneys and how I think they've really, really hurt his chances for appeal. My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. The appeals issue here is double jeopardy or contracts issue. Simply put, they're saying that we had a deal with the prosecutors at the beginning, and that deal was they'll drop charges and Jussie will do 2 days community service and forfeit $10,000 bond. So if that's the case, then prosecuting Jussie again and punishing him again for the same crime would essentially violate double jeopardy. He was punished twice. So let's see what their arguments were before and after. Now, this is why this is important, because it seems like his attorneys, they had loose lips and they were saying one thing before and now they're saying something different again. All right, so this is Jussie Smollett's attorney. Now, initially, after Smollett was arrested and then the prosecutor dismissed the case, his attorneys did a national media blitz, and they were going on television show after television show after morning show telling people that Jussie was innocent and that he pleaded guilty to nothing. And they had no deal, absolutely no deal with the prosecutor. He wasn't prosecuted, none of that, right? He wasn't prosecuted, he had no deal. Instead of me telling you, let's listen to his attorney the day after, I think this maybe a day or two after the charges were dismissed by the state's prosecutor's office. She's going to explain to you whether the bail and the community service were conditions that Jussie needed to do to get the dismissal or not. So we're going to figure that out right now.
Strictly with the prosecutors who were actually handling the case.
Now, the prosecutor's office says that the charges were dropped in exchange for your client's agreement to forfeit $10,000 that he had paid in a bond and to do community service. Is that correct? Were those conditions on his dismissal of charges?
There were no conditions, and obviously there was no plea, there was no agreement in place. They did want him to forfeit the bond, and that's something that we discussed with him and he initially struggled with because he didn't want the perception to be that he had done anything wrong. But at the end of the day, forfeiting $10,000 versus putting your life on hold for a year was a small cost to pay.
But to be clear, because the prosecutors are now trying to say, well, there were conditions. This wasn't a get out of jail free card. You're saying he chose to forfeit that bond essentially voluntarily.
Yeah, they had asked if he would do that, and we advised him that he should do that because it was going to cost him almost, multiples of that number to go to trial.
What about the community service aspect of it?
The community service is something we initially raised ourselves at the initial bond hearing, saying this is somebody who's volunteered hundreds of hours, thousands of hours since he was a teenager to all sorts of organizations. It's something he's always done. So in our discussions with the prosecution, we told them about his volunteer service. We did show them a few letters of his ongoing community service to show that
was this a condition of the charges being released? He's got to do this community service.
He had to do nothing. There was no obligations, no conditions. These are things that he chose to do because that's his character. And again, you can find out from multiple sources that this is what he's done for years and years and years with multiple organizations.
Let's talk about...
So I need you to be clear. He did all of that. He did the community service. He gave up the bond voluntarily. There was no conditions, absolutely no conditions, right? He just did that because he's a good guy. That's what she said. That's what she just said, right? They had no deal. There was no deal. Absolutely no deal. Charges were dismissed. He was never in jeopardy, never had a deal. You're crazy to even think that. That's what she's saying. That's exactly what she's saying. There it is, right? March 28, 2019. So we know exactly what she said. We know exactly. And this is the same lawyer. She's still representing him, right? This is the same defense team. So now, Jussie's been convicted. What's their argument for appeal? So let's go to Jussie's attorney again, right? And let's see what the attorney's argument is going to be now. So here's Jussie Smollett's other attorney. Now, remember, they've been saying for almost about a year or 2 years now that there was never a deal. He did all this stuff voluntarily. There was no deal, no deal. Now, their client's been convicted. They said there was no double jeopardy because there was no deal. Now, listen to how the story has changed. Again, these are his attorneys. Listen to what they're saying.
3 years now. Just the basic one I will start off with is the fact that the prosecutor's office originally dismissed this case. Now,
Correct.
a lot of people can disagree as to why they did, but the reality is they dismissed the case. And he was made to do community service and give up a $10,000 bond. He's not getting that $10,000 bond back, and he cannot undo the community service he did. Another prosecutor was appointed on behalf of the state to prosecute the same case the state had dismissed before. And really, it's an ancient principle: a deal's a deal. Regardless of how anyone feels about it, this prosecution shouldn't have even begun after that dismissal initially.
This is where you get the both sides talking out of your mouth, right? Because he's out there saying, a deal's a deal, right? A deal's a deal. But your office, this defense office, right? This defense team has been saying for 2 years there was absolutely no deal.
And so he has done volunteer service. I know there was some questions about the Push Coalition. They put a statement out saying that there was no court-ordered community service, which is the true facts here. And if you look at the transcripts from the proceedings where the case was dismissed, there's no mention of any required community service either before or after the fact.
On show after show after show after show, he had no deal. He voluntarily did that stuff. He voluntarily gave the $10,000. Same thing with Amy Cooper. Amy Cooper had to go and do what? A race class. Remember that Amy Cooper's the woman in Central Park who called 911 on the black guy and yada, yada, yada. She was arrested for filing a false police report. And she too went to a diversion program. Right? She had to go do race sensitivity classes or something like that. And after she did her race sensitivity classes, they dismissed the case, right? With prejudice. They said, we'll dismiss your case, right? They made a deal. They had a wonderful deal. Jussie Smollett didn't have that wonderful deal. His deal wasn't wonderful. His deal was, we're just going to dismiss the case and you voluntarily do whatever you want to do. And he says, you know what? Because I'm such a good guy, I'm going to give you $10,000 and do 2 days community service. Okay, well, you don't have to do anything. Here's the deal. Now they're saying, no. We were lying for the past 2 years. That was actually a deal. Now, if I'm the state's attorney, I'm definitely going to be using these clips in my, the defense team has been going on for 2 years. Saying there was no deal in public, is no deal on this show, saying there's no deal. He voluntarily did all this stuff. And now they come to the court. And lo and behold, they're screaming, we had a deal. They both can't be true. So what do you think? Do you think the defense team has hurt Jussie Smollett's case by this whole, we didn't have a deal, we never had a deal, and now all of a sudden, we got a deal? These things, either he's lying now or she was lying then. You decide. I'll see you next time. Peace.